The Netherlands is a civil law jurisdiction, which means no discovery, no jury, no punitive damages, no elected judges. The Netherlands has two mechanisms to resolve mass claims. The collective action that was introduced in 1994 and a collective settlement device that was introduced in 2005. And they were two separate mechanisms that could be used independently from one another. Collective action and collective settlement are forms of collective redress. The term used in the Netherlands to define group or collective actions is collective redress. And the term has been invented or introduced by the European legislature to distance from US-style class actions that have a very negative connotation in Europe. So therefore that different, more neutral term was invented, collective redress, to describe a great variety of proceedings existing across Europe that all have one thing in common, that they are not US-style class actions. That is a topic in itself which we will address in a subsequent session. The collective action, as I said, was introduced in 1994, and that was a codification of existing case law until then. According to the Dutch rules of civil proceedings, collective actions can be instituted in practically every substantive field of law. They are not limited to, or restricted to consumer law, for example, or to financial services or to product liability. They have been used in the Netherlands in labor law disputes, in financial law disputes. That trend has been something of the last 10 years. One of our students, Sandra Maris, has written a paper about the use of the collective action since its introduction in 1994 until the end of 2012. And there are some interesting figures that came out from her research. In the time frame, 288 collective actions has been initiated. And there is a clear trend in using the collective action more and more often. In the time period 2007, 2012, more than half of the total number of 288 has been initiated, which is quite a significant increase, I would think. The area of law in which the collective action was used most frequently were securities litigation, insurance disputes, and labor law disputes, of which a big percentage consisted of pension matters. So the goals of the collective action in the Netherlands are the usual one: the process economy, efficiency, and increasing access to justice for claimants. The expectation was that mass disputes would occur more and more in the future, so therefore there should be a device to, a more sophisticated device to allow claimants to aggregate their claims. Basically, any remedy could be initiated through the Dutch collective action device, with one big exception, which is collective actions for damages. Collective actions for damages are not allowed under the Dutch collective action regime, and the reason for that, the official reason for that, was that it was too complicated to accommodate such a remedy, too complicated because the individual characteristics of a claim would make it difficult to aggregate many individual actions for damages. So if a group of, for example, injured victims, victims suffering a personal injury, or consumers would like to collectively ask for damages, they would have to file a collective action for declaratory relief first. After they have obtained that, they could file individual actions in which they have to establish their individual causal link and damages. The Dutch collective settlement is another device within Dutch law of civil procedure to collectively resolve claims. As I already said, the Dutch Act on Collective Settlements was enacted in 2005, and it was enacted for the resolution of a specific case. It was a product liability drug device case, DES hormone case, which led in the late 80s, early 90s to Supreme Court ruling in an individual case, which in its turn led to hundreds of thousands of victims coming forward asking for compensation. At that point, the defendant companies, which were producers of the drugs and insurance companies, some of the producers didn't exist anymore, those defendants found themselves confronted with hundreds of thousands of claims they were willing to resolve, but only under one condition. They were willing to set up a fund, compensation fund for all victims, but the condition was that they wanted to have a guarantee that it would be over with that dispute. And at that point, the Dutch law didn't have any provision, any device that was able to facilitate that. Therefore, the legislature decided to very quickly accommodate this resolution, and therefore the Dutch Act on Collective Settlement was introduced. Some scholars and academics believed that the Dutch Act on Collective Settlements was going to be used only once, only that particular case, and it would never be used again. Up to now, we have had 6 collective settlements approved under the scheme. The first was the product liability case I already mentioned, and the cases that followed were all related to securities litigation or to financial products, consumer financial cases, and 3 of the cases had a cross-border element. The Shell recategorization settlement and the Converium settlement involved were in fact pan-European global settlements. Ideally, the Dutch Act on Collective Settlements would be an ad hoc legislation made only for that specific case. However, in the time that this took place, the Dutch legislature was very much criticized for producing ad hoc legislation with no main policy in mind. So that wasn't really an option. Therefore, the Dutch legislature chose to design the act as a general act that would apply in all types of situations and all different settings. But at the same time, as I said, many were skeptical about the necessity and the options to use the act in the future. The Dutch Act on Collective Settlements has 2 notice requirements. The first notice parties have to send out to all known group members after they filed a petition to invite interested parties to attend the fairness hearing, the hearing where the court will hear the argument of the petitioning parties about why they think the settlement is fair and reasonable and why they think it should be approved. The second notification round is after the approval of the court to inform parties that the court has decided to approve the settlement. And in the second notification, parties will be given the opportunity to opt out if they choose to do so for whatever reason. For example, for starting their own individual proceedings to try to obtain a better outcome. Under the Dutch regime, the court is not required to rule about the fees of the lawyers. The Netherlands doesn't have contingency fees. At least I should say, lawyers are not allowed to charge contingency fees based on their rules of professional conduct, based on ethical rules. So funding could be quite problematic. That is a very important theme, which we will address separately in a subsequent session. An interesting feature of the Dutch collective action regime is that ruling binds only the association that brought the action and not the individuals that are part of the group, which means that, means in practically speaking, in practical terms, that if a collective action is successful, then individuals could free ride on the outcome of the collective action when they file their individual suits, because that collective action ruling is expected to have some kind of a reflex effect on their individual claims. But if the action is not successful, they could simply start their own individual proceedings trying to establish liability in their individual case. So that is, I think, important feature, an important difference with other collective redress regimes where the ruling is binding for every party who is part of the group and who didn't opt out, for example. The Dutch collective action has been designed in the European, I would call it, institutional tradition, which means that no individual claimants or victims are allowed to file a collective action, but it always has to be a non-profit foundation or association that is entitled to file such an action in accordance to its article of association. So when a judge would have to determine whether the association or action has standing to file the collective action, it would look at the articles of association of that foundation and at the scope of the action, and the two of those have to be compatible. Another requirement for admitting a collective action, according to the Dutch statute, is that the nature of the disputes allows for aggregation, which is a vague criterion, but there has been some case law to try to determine the exact terms of that statutory requirement. A last requirement for the admissibility of the Dutch collective action is that the association that plans to initiate a collective action should have tried to reach what I have in mind out of court first. But again, that is also a not that difficult to meet requirement. So one of the main criticism on the Dutch mechanisms to collectively resolve claims is that neither of them works without the willingness of a defendant to cooperate. To use the Dutch Collective Settlement Act is needed that the defendant is prepared to reach a settlement out of court. If the defendant is not prepared to do so, then the Dutch collective action device is useless. On the other side, the collective action for damages, obviously the cooperation of defendant is not needed, but there are scholars that argue that the absence of the possibility to collectively file for damages makes it difficult, if not impossible, to put the needed pressure on defendants to settle. So in recent years, there has been a debate in the Netherlands whether the Dutch collective action regime shouldn't be modified to allow to collectively sue for damages. So on the other side, there is the collective action, which doesn't allow to collectively act for damages. And it has been argued that the absence of such possibility makes it difficult for claimants to put enough pressure on defendants to settle cases. So many believe that therefore the collective action is inadequate. In recent years, there has been a debate to modify the collective action to allow such a collective action for damages. The discussions are still ongoing. The Ministry of Justice is preparing a proposal to amend that, but no details about that proposal has been revealed to date. At the same time, the Dutch legislature has introduced a couple of different separate instruments which he believed would be instrumental or helpful to facilitate out-of-court settlements. Like, for example, the prejudicial questions scheme, which allows lower courts, district courts, to file directly to the Supreme Court a prejudicial question to interpret the law, which sometimes might keep parties apart. Another mechanism to facilitate parties in reaching out-of-court settlement is the pre-trial conference, which means that each of the parties usually involved in collective actions could file a request with a district court before any action has been initiated to hold a pre-trial conference in which the court will explore whether he or she could facilitate the parties in reaching a settlement. And the court, for example, could appoint a mediator or special master. And that can happen before any lawsuit has been initiated. That provision was introduced in the summer of 2013, so we haven't had experiences yet. That's been too recent. As we already said, in collective action, different types of remedies can be initiated, like declaratory relief, injunctive relief, Cypre distribution. In 48% of all cases that has been initiated between 1994 and 2012, the ultimate goal of the action was financial relief, which means declaratory relief has been initiated to request the court to determine that a company or a party has acted unlawfully, to initiate subsequent individual actions for damages. Another controversy that is good to mention, and which somehow relates to the competing collective actions, the parallel proceedings, is the governance of ad hoc established foundations. It turns out, based on recent experiences with financial collective actions, that it is fairly simple, fairly easy to ad hoc establish a foundation. Foundation that could be misused by commercial entities and who doesn't have a proper governance structure. Therefore, about 2 or 3 years ago, there was an initiative on the part of the bar and lawyers who act more often on the side of claimants, to come up with a so-called claim code or claim governance code that stipulates or prescribes extra requirements for the board and advisory board of such ad hoc foundations, the purpose of which is to improve the governance of ad hoc foundations. The criticism that one could think of with regard to the code is that it imposes too much administrative and too much bureaucratic burden on the functioning of the foundation, whereas the foundations have already a quite difficult task in putting together such collective actions. So that makes it more complicated in a way. On one side, the claim code tries to improve the governance and the appearances of ad hoc foundations. On the other side, it makes it, in a way, more difficult also for the so-called good ad hoc foundations to act as claimants in collective actions.